I'm going to take my mask off because I'm far enough away from everybody. I can social distance and safely take it off, and I'm going to be doing, as we get started at least, a lot of talking. There will come a point when I'll be very interested in hearing reports from caseworkers and from other folks, and then if it's easy enough for me to put the mask back on when I'm not talking, I'll do so. Is everybody else, though, comfortable that you're the appropriate distance from everybody that you should be? We're trying to do the double safety of both masks and social distancing, although both aren't required. But move around to the extent that you want to or need to so that you're comfortable, okay? Because that is important to me. And I hope you respect the fact that I get the privilege of not having the mask on only because I am far away from everybody and because I am going to make a record before we get to the review hearing stage. And it's going to be me talking a lot, and it will be easier for me to do that in light of the fact that I got to use my glasses without the mask on. So let me have the case called, please.
Calling case number 2019-878-766-DL in the matter of Ayanna Grace Odom Foxworth.
Thank you very much, sir. May I have your appearance?
Good morning, Your Honor. Justin Chmielewski, Assistant Prosecuting Attorney on behalf of the people.
Thank you, sir.
And Tricia Deere, also appearing on behalf of the people, Your Honor.
Thank you, ma'am.
Good afternoon, Your Honor. Ashley Bishop on behalf of casework.
Thank you. Sir, on behalf of the juvenile.
For the record, Your Honor, John Burnett on behalf of Ms. Odom Foxworth.
Thank you, sir.
Simon Khalil on behalf of Ms. Ayanna Odom Foxworth.
All right, so you're both here on behalf of the child only.
Yes.
That's correct.
Okay, so you haven't engaged in any representation in any form with regard to this matter on behalf of mom?
No, we are representing the child, Judge.
Have you engaged in any representation on behalf of mom in this matter, though? I'm sure that they'll be ready and willing and able to waive conflict, but I'm going to waive conflict if it exists.
Yes, Your Honor, we would ask you to waive any conflict.
Okay, I can't waive conflict, they have to waive the conflict. So I'm going to have to put both your client and her mother on, and is mom here? Mom under oath, so if you could both stand and raise your right hand to be sworn, I'd appreciate it. Thank you. Mr. Slayton?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you very much. So you've got a question to waive conflict, please.
Ms. Odom, Ayanna, do you have any issue with us representing you as well as your mother in this matter?
No.
Ms. Odom?
No.
Judge,
Okay.
is it possible to have Ms. Odom sit with us?
No.
Next to her daughter?
No. This case is about her daughter.
I understand that,
And
Judge.
she is exactly where she should be, sir.
Typically in a review hearing, though, in a juvenile review hearing, I have the client's parents sit with them.
Okay, I'm going to have, this is good right here. Are you indicating that you have offered mother representation in this matter?
In that we're advising her as to what's going to happen or hopefully happen today and going forward, Judge, yes.
So, I'm just trying to make sure that folks aren't saying there was a conflict of interest that the court didn't address.
Okay.
Because these two folks, while mother and daughter, come to cross purposes. And mother has testified against daughter. Mother has made numerous accusations against daughter. So I want daughter to understand, I want Ayanna to understand. Ayanna, do you understand that you're entitled to representation that you're comfortable with? Someone who is looking out just for your best interest. Do you understand that?
Yes.
Are you comfortable you have that?
Yes.
And you're saying that you're not going to have anybody say on your behalf later, wait a second, that wasn't fair. He was doing what my mom wanted, not what I wanted or what was best for me. He was doing what my mom wanted. Are you comfortable?
Yes.
Okay. And I guess in terms of mother waiving conflict, that's between you and her. If because she's not my concern to the extent that I have jurisdiction over the young lady. As long as she's waived conflict, I'm comfortable. If mother feels that there's something inappropriate that's happened in terms of the representation, she'll take whatever action she wants to take. But I'm accepting her waiver, that she knows that you have also consulted to some extent with her mom, She is understanding that sometimes her mom and her are at cross purposes in terms of what's going on, and she's okay with it. So I'm accepting that she's okay with it.
Thank you, Judge, and I just, for the record, Ms. Khalil and I have Ayana's best interests at heart. And I can assure the court that we're representing her to the best of our ability, and I don't feel that there is any conflict in our representation of Ms. Fox.
Well, the
Ms.
conflict would be
Foxworth.
if you're representing two people whose interests...
I understand that.
Okay,
Yeah.
so if mom is making accusations and calling casework and saying, she's not following my rules, help me out here, that could be contrary to your client's interest, and I just want to make sure that your client is comfortable with you representing both her mom, the caller, and I'm using a simplistic example, but the caller, and also Ayana. Ayana may take the position, I want to be home tomorrow, and her mom may say, no, I really think that she could benefit from finishing this program out and continuing her goal. My point is that they could be at cross purposes.
I understand, Judge.
As long as everybody's informed and your client waives it, I'm good.
We're all on the same page. Both mom and daughter want daughter home.
Okay. Have you had an opportunity, counsels, to watch all of the videos? So the 2 dispositional hearings and the violation of probation hearing and then the brief detention decision?
No, Judge, I'm glad
Have
you
you
brought
had
that up.
wait, hang on, sir. Have you had an opportunity to watch the videos?
I have not, Judge.
Okay, so you are here and you have made a request for specific relief and you haven't even watched the videos?
Judge, we were retained on Tuesday. We weren't able to procure the videos. If the judge, if the court...
Have you had an opportunity to review the social and legal file in this case prior to filing your motion?
We received the court file today, this morning. We received, prior to the hearing starting, a report from Miss Dr.
Would you mind
Scott
standing
Porter.
when you're addressing the court?
apologize.
I respect you.
I
That's the
apologize,
process.
Judge. I was-
Okay. Have you, I'm asking you a specific question. See, you're having the same problem.
I
That's
can't
exactly why my
see
mask
with
is off, sir.
I can't
So
see with my
That is
glasses.
exactly why my mask is off. Have you reviewed the social and legal file in this case? Not the casework report, the court file.
We have reviewed the court file.
You've reviewed, including the social file?
What was provided to us, I believe, is the complete file.
When was it provided? How was it provided?
It was provided by my client's mother, Judge.
Okay. Have you reviewed the prior Child Protective Service reports? Any of the prior proceedings from 2017 on?
No, we have not, Judge. But if given
Wait,
the opportunity,
hang on,
you
sir.
would.
What? Hold on. You have the opportunity. The minute that you file your appearance, you can have access to all. You have access to all of the videotapes, counsel. You have access to all of the social and legal file. It is disheartening that you file a motion for specific relief and you haven't even come up to speed in terms of the case.
Judge, there's enough in the file that we read to warrant release.
Okay.
The probation
Okay.
officer in this matter, Judge, filed a violation without even speaking to
All
her
right, Mr.
teacher
Marinette,
or her therapist.
I've got it on.
Judge, if you wanna get
stop.
into the
You've
facts-
indicated on the record that you didn't review the social and legal file and you didn't review the videotape.
Judge, this motion
Sir,
was filed
stop.
on Thursday.
Stop. The motion was filed on Thursday. I believe your appearance Thursday at
The court's closed.
4:50.
How would I get
Stop.
that information?
You have, the court is not entirely closed. Let's just be clear about what you know. All right, I've accepted respondents' waiver on conflict. Let's be clear also, before we get going, about what my role is. This gets really easy for me, because my job, my role, is to make decisions that are in this young lady's best interest, period. I took an oath that I will not be swayed by partisan interests, public clamor, or fear of criticism. And I'm going to uphold my oath. This young lady is in a Children's Village treatment program, receiving services pursuant to an amended disposition on a charge of domestic violence with her mother as the victim and larceny in a building. She is in a treatment program. The purpose of juvenile justice is rehabilitation, not punishment. That's why she's in a treatment program. So this morning, this is how it's going to go. I'm going to have an opportunity to set out a framework. How did we get here to this hearing today? Then I will hold the review hearing. And you made a request for an expedited review hearing. One is currently set for September. You made a request for an expedited review hearing under 3.945, which I granted, and absolutely believe that it's appropriate. The purpose of that review hearing, though, is not to relitigate everything. The purpose of the review hearing is to take a look at the last dispositional order, the one placing her in Children's Village program for treatment, and make a determination whether or not that should be changed. So I'm most interested in a report from the placement and how she's doing and if she's benefiting and if she's engaged. I'm most interested in the outcome of a psychological that I literally just got handed, and you probably did too, so I'm going to give you an opportunity to read carefully. I'm most interested in, the purpose of a review is, here's where she is, how is she doing, and should I change the order? You want me, and hopefully you come with an open mind and an open heart, because I do. I want to hear everything. I want to know how she's doing. I want to get a recommendation from people who are working with the family. I'm sure you do as well. I want to review the psychological. I want to see what the issues are that got us here. I'm sure you do as well. So I will give you an opportunity before you take a position that may be contrary or maybe the same as what you took in writing, that she should be released from her treatment program without finishing it, without achieving her therapeutic goals. I'm going to give you an opportunity to talk to your client and see if that's really what she wants after she hears from casework, after she hears the information that's contained in the psychological. After she hears folks saying, this is what I think should happen now, and here's why. I'll take a break and give everybody a chance to talk. Have you had an opportunity, because I'm getting things late too, because you asked for an emergency hearing, so we're all going to kind of get handed things at the last minute. Have you had an opportunity to review the psychological?
We just received it this morning, Judge.
Have you had a chance to review it?
We just briefly reviewed it prior to you taking the vote.
Okay, thank you, sir. Have you had a chance to review the court report from the village, from her treatment program?
No, Judge.
Okay, I'll give you an opportunity to do that before you make a final request, because I want to be educated, and I know you do too, in terms of really what's right here. Have you had an opportunity to review the casework report? The report and recommendation from the casework?
I have the case notes from both Ms. Bishop and Ms. Guru.
There should be, I've got a court report, I've got a psychological, and I've also got a report from casework that I can't put my hands on. But I'll make sure that you have an opportunity to see all those and read all those before you make any final decision about what you want to request for your client. So you can get comfortable if you'd like, everybody can get comfortable, and now is my opportunity to kind of frame how we got here. Okay, and this was not an easy decision to make, Ayanna, how thorough I wanted to be in terms of how we got here. I have to make a record so that we're all on the same page. We all are operating from the same information. So this morning, for you, respectfully, is going to get worse before it gets better. Because I'm about to go over all the crap, all the negative, all the prior attempts at helping, and I'm going through it all. So that we're all on the exact same page. Okay, now here we are. Now you're in the TAG program at the village. Should you stay in the TAG program at the village and hopefully complete it? Or should I send you home and make some change of plan? That's where I'm good. That's what I'm going to decide at the end of this morning. But if we all aren't on the same page in terms of how we got here, none of us can speak intelligently. This matter was initiated on December 9, 2019, when a petition was filed charging Ayanna with domestic violence for an assault upon her mother. The assault occurred November 6th. The complaint reflects that she was fighting with her mom in the street, reached into her mom's car to try and take her cell phone, and in the assault, she bit her mother's hand and pulled her hair. 8 days later, a new petition was filed alleging that she committed a larceny from a building on November 11th by stealing a phone from the boys' locker room at school. When confronted by the assistant principal, she attempted to grab the phone from him. That petition was filed December 17th. On January 7, 2020, mother and child failed to appear for a pretrial on the petitions. On January 15, 2020, mother and child failed to appear for a pretrial on the petitions. On March 3, 2020, Ayanna pled no contest to the domestic violence, and she pled guilty to the larceny in a building, and the court reviewed the police report in order to have the factual basis for the larceny in a building. The domestic violence, I switched them. She pled no contest to domestic violence, I reviewed the police report. She pled guilty to the larceny in a building. Disposition, if she were an adult, it would be called sentencing or outcome. Disposition was scheduled for April 21st on those two charges. And in preparation for that hearing, the court reviewed the court's file in its entirety, including 34 pages of Child Protective Services reports. I am going to inform the record of some of the information that's contained in those reports, nowhere near all of it. It's 34 pages. I'm going to hit what was important to me when I looked at it the first time and what's important to me today. The court had an opportunity to review a mental health petition, a request filed by mother that was made by mother for a mental health hold against her daughter in 2017 as well. So the first CPS report that I had an opportunity to review is from 2017, April of 2017. The report was made that mother and daughter had gotten in a physical fight, an argument that escalated to a physical fight, and that at the end of it, that mother, Melanie, told Ayanna not to come home today because she wasn't going to let her in the house if she came home. Both mom and daughter were interviewed, and they appeared to both be forthcoming in the interview. Mom said that she attempted to look under a washcloth that Ayanna had. She was hiding something. Ayanna started yelling and began pushing her. Mom stated that Ayanna was pushing her, hitting her in the head, and continuously hitting her in the waist. And she said she too was pushing her daughter away while her daughter was swinging at her. Mrs. Odom reports that she was not even aware her daughter had scratches. That's how it came to the attention of folks at school. But she says she had been attacked by her daughter numerous times in the past. Mrs. Odom reports that she has had busted lips, been punched in the eye, had her back jumped on, been knocked down on the floor, and that her daughter is incorrigible at home. She was visibly shaken when speaking of the incident and incidents in the past. Local police had been called 3 times. She indicated she could not control Ayanna when she became upset and out of control. Mrs. Odom states that her daughter has a history of sexting, speaking with older men on social media sites, and connecting with the wrong people. Mrs. Odom reports that the warnings from the school, the police at her home, and interventions from family members have not worked. She reports that Ayanna stole 4 iPads from her school, but her school didn't kick her out permanently, but instead gave her in-school suspensions. Ayanna was interviewed. She indicates that she was trying to sneak makeup, and that's what the fight was over, trying to hide it from her mom. Ayanna reports that when her mom wouldn't leave her room, she put her hands on her mother. She said there was a struggle that included her pushing, scratching, and kicking her mother. Ayanna states that her mother tries to restrain her during their disputes, but often she cannot. Ayanna acknowledges that they have incidents like these often. I'm reading word for word from the report. The second one that the court had an opportunity to review is from March of 2018. They had a disagreement. The report came in that Ayanna stood over her mother. Mother said she had a look in her eye and started hitting her. During the attack, mother bit Ayanna, so mom bit daughter on the right lower forearm to get her off of her. The police were not involved, but the aggression escalated from pushing and shoving, to a violent attack of Mom. And and then she referenced that no police were involved in this, but that a few days before, there was a time when Ayanna had jumped out of her mother's vehicle without permission, and law enforcement was involved in that one. So both were interviewed again. The details are that they had gotten into an argument and began fighting because her mother locked the password on her Kindle. She reported that this is Ayanna, she reported she got upset and blacked out, doesn't remember how the physical altercation started, but acknowledges that they were wrestling, and she says that she hit her mom at least once. She was fighting with her mom. They were rolling on the floor, and she was trying to take her mother's purse. She says, according to Ayanna, this is not the first time she's been physical with her mom. 2 weeks ago, she said they had a physical interaction, and that she will usually start the fights with her mother. After a recent interaction that was physical, she was staying with her cousin for a period of time for a cool down. Cool down is my term. It just says staying with her cousin. She also reported an additional incident in the family's vehicle. Ayanna wanted to go to Burger King and got upset when her mother said no. She reported that her mother tried to take her to the police station and that she grabbed her mother's hands, and they were next to the Burger King, so she just jumped out of the car and went in. She reported that she is only physical with her mom and not with other people. There was interaction with Birmingham Youth Assistance as a result of some of this. Here's Mom's version of this most recent protective service, one that I'm reading from. She reported that her daughter Ayanna assaulted her, and mother was on the floor on her back, and Ayanna was bashing her head into the floor. She says she bit her arm to defend herself to try and stop the assault. She reported she did not contact law enforcement, this is Mom, because she was fearful Ayanna would be arrested. She did report, however, law enforcement was contacted a couple days prior when they were driving and she wanted to stop at Burger King. Mom says she grabbed the steering wheel. Mrs. Odom stopped the vehicle to avoid getting in an accident, and Ayanna exited the vehicle without permission and went to Burger King. Mrs. Odom reports that the behaviors have continued to get worse. After this incident, records note that Ayanna's aggression towards her mother, after this incident, they started some family therapy. So here's a note from the family therapy session. The record notes that Ayanna's aggression towards her mother is getting worse. She is defiant and demanding. The records also indicate that she may have a disorder that surrounds social media and internet addiction. It was recommended that Mrs. Odom file an encourageability petition against her daughter, and she did. So she filed legal paperwork alleging that her daughter didn't follow the reasonable commands at home. Mrs. Odom appears to send Ayanna to relatives at times during breaks instead of spending time with her. That was one of the issues that they were having a conversation about in therapy. The next protective service report is from June of 2018, so about 3 months after the one that I just referenced. The original information that comes in is that there's a history of police responding to the home due to physical altercations. On this particular date, another physical altercation. Ayanna wanted car keys out of Melanie's purse in order to get the charger out of the car. Melanie's mom. Melanie refused to allow Ayanna in the car because she's currently under a court order that does not allow her to be in possession of electronic devices. That was as a result of Mom filing the encourageability petition. Melanie and Ayanna began fighting over the purse, pushing and shoving each other. When the police came to investigate that incident, they found an iPad that had been stolen from school that Mom wasn't even aware of, but they just stumbled into it when they were at the house dealing with the assault. There's discussion in this protective service report why Mom dropped the encourageability for Ayanna. Mom explained that her grades, that she said that they were taking a different plan. They did have a meeting with the referee, but they had a plan in place. And it appears to be an appropriate plan. Mother explained that her grades were slipping, she was using inappropriate websites, having other people provide her with electronics, and stealing. Melanie said the school didn't press charges for the stealing of the iPad, but it looks like at one incident that she was suspended for her last week of school. I don't intend to completely inform the record, but there needs to be at least a sense of the history. A lengthy disposition, so that's like a sentencing hearing, a lengthy disposition on the 2 charges was held on April 21st, 2020. The court reviewed, in addition to what I just read into the record in its entirety, the court reviewed a casework investigation and report, as well as a detailed out-of-home screening committee recommendation. At that hearing, the court heard recommendations from all the parties, including Ayanna and mother and Ayanna's counsel. So the information that the court had prior to that first disposition, I'm going to make reference to information that's contained in the out-of-home screening committee recommendation just briefly, and the casework investigation report. So this is the information that's been gathered on the family, gives us a social history, police contacts, all that type of information that hopefully lets me make an educated decision when I'm deciding what to do at disposition for domestic violence and theft of property, larceny in a building. In regards to the domestic violence petition, Ayanna met with the caseworker, reported that she wanted to go to a friend's house and her mom told her no, that the situation escalated and her mom went out to her car. Ayanna described this is where her mother goes when she feels like Ayanna is escalating. Ayanna stated that she thinks she was reaching for the phone through the window, her mom rolled the window up on her arm, and that her mom was driving down the street with Ayanna's arm still in the window. She stated that her mom claimed she grabbed her hair. She said she spent the night at her aunt's house following that. As far as the theft of the phone, she says she just went in the locker room, took a student's phone, that it was a dumb decision, that she lied about stealing the phone, but the police had it on video, and so there was an interaction with the assistant principal to get the phone back. Mom describes this domestic as she was slowly backing out of her driveway, but Ayanna was struggling with her. She started honking her horn and was slowly driving down the street. She says that Ayanna bit one of her fingers and pulled a clump of hair out of her head. In terms of police contacts, the court was informed that the police have been called to their home multiple times since 2016, some with incident reports and some with just run sheet, just that they were out there to settle something down. In 2018, there's a reference to when mother drove to the police department to discuss the increasing incorrigibility of Ayanna, telling the police that report that she made, that mother made episodes of yelling, screaming, and pushing. Mrs. Odom indicated that Ayanna was at one time placed on a diversion program and had broken the guidelines. In terms of family trouble, one of the run sheets, Mrs. Odom wanted to go to parent-teacher conferences, and she wanted Ayanna to go with her. Ayanna was refusing, so police officers stood by to get Ayanna into the car to go to the conferences. Ayanna was placed on diversion in April of 2018, and after Mrs. Odom filed for home incorrigibility, Mrs. Odom was reported to be uncooperative at times with the services being offered. Ayanna did have one stride punishment while she was on diversion for not complying with the school requirement. Mrs. Odom reported that she dropped the incorrigibility because she wanted Ayanna to attend Camp Culver, which the court, not this court, but the court that was presiding at the time, I believe it was the referee, agreed with, and then that case was closed appropriately. Ayanna was also referred in the past to youth assistance by her mother for behavior concerns at home and in school. Youth assistance records reflect that Ayanna was uncooperative in meetings. In 2018, she was referred to youth assistance again by the police for assault concerns against her mother. In terms of mental health, there's information with regard to starting counseling, receiving some level of services, and then it's some time passing and a different approach to counseling and receiving mental health services. This struck me on the date of the disposition, and it's striking to me again. She stated that the mobile crisis team, so mom made a call to the mobile crisis team, was called last a few weeks prior to the social history interview. So this is after the plea and before the disposition, mobile crisis team is called out. Mrs. Odom stated that she wanted Ayanna to be removed from the home. However, individual and group counseling was recommended. Ayanna has also participated in the face-to-face day program through New Oakland Family Centers, which was also recommended by Mobile Crisis Team. However, mother reports that Ayanna stole a phone when she was at that counseling. In terms of mental health history, she was previously hospitalized at Beaumont for 3 days after a suicide attempt, was evaluated at Common Ground with the condition that she would attend Common Ground Sanctuary, which is the long-term residential. However, Ayanna refused to attend once she was released. Ayanna reports being consistently verbally abused by her mother, as well as physically abused. Ayanna states that the arguments, etc., are a weekly thing with her mom, and, quote, she thinks she has so much power. When Mrs. Odom filed a home incorrigibility, she reported that Ayanna had grabbed the steering wheel while she was driving, that she screams while she's driving, and that she ransacks the home. Mrs. Odom reports being exhausted and stating that her behaviors have continued, if not gotten worse. She says she goes from 0 to 100 when she doesn't get her way. Most of the arguments that Mrs. Odom and Ayanna have are over mother not allowing Ayanna, to use a phone or social media. She reports that the daughter, Ayanna, reports that she steals phones out of desperation and that all her actions are because she's going through a challenging time. Mrs. Odom reported that she's been staying in her room because Ayanna screams, is verbally abusive towards her, and blocks her from going from room to room. Mrs. Odom has reported that Ayanna assaults her by pushing her, biting her, choking her, spitting, and punching her in the head. Ayanna stated she's been trying to hold back, and that in terms of the spitting, she's not spitting on purpose. When she yells, she spits. Mrs. Odom reports that Ayanna has impersonated a boy on the internet and was also found looking at pornography and talking about sex with friends online. In terms of school report, and this is the information we all are getting ready for that first disposition. She reports that she has had in-school suspensions. She was not given sanctions for thefts that were caught. In June of 2018, she was suspended for the remainder of a school year for stealing an iPad. Child Protective Services made the reference to the 4 iPads that were stolen from Berkshire Middle School. Now we're talking about high school, current, prior to the health crisis, prior to the pandemic. Ayanna reported that she failed 3 classes this year. She stated that her grades were poor due to her not doing her homework and having a lack of organization and motivation. Mom has taken the phone away several times due to her not doing her schoolwork. She skipped class on one occasion and had a detention. Suspended this school year, meaning the high school year, for stealing another student's lunch and money. Mrs. Odom stated that Ayanna expressed being tired of eating the same lunch every day and stated that Ayanna has stolen checks and gift cards from her in order to take money and buy food at school. Although Ayanna reported she's never put her hands on a teacher or administrator, she admits she has struggled going back and forth physically with school officials when handing over stolen technology. She does have, it was identified, she had a 504 plan in terms of meeting her educational needs, and as of January 2019, she had an individualized education plan. I made myself familiar with the supports and the accommodations that were available to her and that she was entitled to under her IEP. I am the mother of a teacher, I'm the sister of a teacher, and I'm the daughter of a teacher. The worker presented this matter to Out-of-Home Screening Committee on April 15, 2020. And the Out-of-Home Screening Committee recommended that she be placed on a Children's Village order, what she's on now, okay? But this is way back. There was a recommendation that was a well-reasoned and appropriate recommendation that she be placed on a Children's Village order so that she could participate in counseling, anger management, and receive psychiatric services. And it was also recommended that the mother participate in parent education. In terms of willingness to comply, Ayanna does not believe that there's a need for her to be placed outside of the home. Mother strongly believes that Ayanna is in need of short-term intensive therapy with long-term residential care, and has suggested that she do this through Common Ground Sanctuary. So this is the information I've got going into the disposition, the first disposition. Out-of-home screening, I don't need to go through that. They just capture long history of stealing at home, in the community, at school, mother fearful of behaviors, many counseling attempts, services offered, not completely followed by parent or child, mother wants long-term residential, however, mother needs to participate in services, lots of CPS, huge social media issues, so that's why that was their basis for recommending the Children's Village order. Exactly what she's on now, months later. At that hearing then, so let's make sure we've got the right date. This was our original disposition on April 21st. Oh, thank you, ma'am. Pardon? Thank you. At that hearing, the caseworker, the assistant prosecutor, the out-of-home screening committee report all recommended that Ayanna be placed at Children's Village and screened for an appropriate program to receive services. Her attorney requested intensive probation. So Ayanna's attorney requested intensive probation. At the conclusion of the hearing, the court placed Ayanna on intensive probation and articulated very clearly that she needed to comply completely or be found in violation. I think I said at that hearing, the last time I watched it was last week, but I think I literally said, you're going to wish you were at the village. I'm going to put so many conditions on you with regard to this probation because I don't want to set you up for failure, and I'm really concerned that this isn't the right fit, but there is a pandemic, and I'm concerned about your physical safety, and I'm concerned about the safety of the folks at Children's Village. Your mom is now telling me she'll receive you home. You're begging to go home, and I made the decision to place her on intensive probation with a ton of conditions. And I stated on the record and state here today that one of the considerations was COVID and was not changing that environment if I didn't have to, if everybody could be safe with me not changing it. So her probation was strict. It was child had to be on a GPS tether, home confinement, participate with a psychological evaluation unless one had been done within a year, could only use electronics from school for educational purposes. She couldn't have a cell phone until her probation officer thought that that would be healthy. Mother to participate in the Children's Village Parent Project, which is a parenting environment, and it's a class and a group that has gotten rave reviews, and I'm talking about reviews from parents who have come through it and have come back and said, we're still meeting. So mother needed, and I ordered her to participate in the Children's Village Parent Project parenting program. I allowed Ayanna access to video games, but with no internet access to block the internet or the inappropriate contacts, hopefully. I indicated that any alleged violations were to come straight back in front of the court, any alleged violation. She agreed that she would obey the reasonable and lawful directive of her parents. She agreed that she would attend school as directed and complete her work to the best of her ability. That's what she agreed to when I released her on intensive probation. On May 6th, early on in her term of probation, a petition was filed alleging that she had violated her probation by using social media on her school computer and by failing to complete her assigned schoolwork. The caseworker appropriately requested 3 things in her petition. She, number 1, wanted me to have a hearing and make a determination whether she had violated her probation. She, number 2, was requesting detention, and she, number 3, was requesting that the court consider a change of plan. So there were 3 distinct things that I was asked to do as a result of that petition. So the first thing I did was hold a violation of probation hearing. A violation of probation hearing was held on May 14th. At that hearing, the assistant prosecutor called witness Rachel Giroux, if I'm pronouncing her name correctly, Ayanna's caseworker. Ms. Giroux testified that she had received numerous phone calls from Ayana's mother, indicating that Ayana was having issues at home and with school. She informed the caseworker that she was, quote, not doing what she's supposed to, not following directives, including to get out of bed, not doing her schoolwork, and was on social media, TikTok, all in violation of her terms of probation. Ms. Giroux testified that she confirmed with Ayana's teacher that she had completed no schoolwork since being placed on probation. There are case progress notes that reflect that interaction. This is between Ms. Tarpey, the teacher, and Ms. Giroux, the caseworker. So to Ms. Tarpey, mother has informed me that you have reached out to her stating Ayana has not been completing work in a timely fashion. Response, this is true. Ayana is not completing any work. Is there, Ms. Giroux, is there a certain percentage of a class she's supposed to be completing a day, a week? Response, yes. Ayana needs to complete the assignments in Google Classroom on a daily basis. She and I will meet from 1 to 1:30 daily after class to get her on track. Is there an outline of, Ms. Casework, sorry. Is there an outline of what assignments have to be completed and their due dates? Ms. Tarpey, everything's clearly outlined in my Google Classroom. It was mother's numerous calls reporting Ayana's behavior that resulted in this violation of probation allegation. Ms. Giroux discussed the school issue with Ayana and quoted her as saying in her testimony that she is, quote, not getting up and, quote, doesn't want to do it, referencing her schoolwork. The court found Ms. Giroux's testimony credible. Importantly, Ms. Giroux testified that she confirmed with Ayana's teacher that, quote, absolutely nothing is being turned in. She did nothing. The court also heard the testimony of mother and Ayana. Mother's testimony was credible in part and not credible in part. In sum, Ayana did absolutely nothing towards her educational requirements shortly after being placed on probation. She refused to get out of bed. She refused to log on, to attempt to figure out what was going on. She refused to follow reasonable requests of her mother, according to her mother on numerous occasions. And the court found her guilty of violating her probation. So that's the end of that hearing, and I've made a finding. So draw a line in our minds. The next decision I have to make is, between now and when I hold an amended disposition to talk about, okay, what next for this kid? What do we do in the interim? Does she go home or is she detained? There was a request by casework and the assistant prosecutor to detain her pending the amended disposition, which was scheduled for June 4th. The court heard argument and found that detention was appropriate. This is a case of numerous instances of domestic violence. Ayana is the perpetrator and her mother is the victim. It is important to note that it was mother who initiated the violation of probation, mother who testified that she refused to get out of bed, and Ayana, I don't know whether she learned it for the first time at the hearing, but she very well may have, unless her mom told her ahead of time. The reason we're going in is because I called. The alternative to detention was ordering the perpetrator and the victim home together, post-hearing. So we finished the hearing. She knows I'm doing an amended disposition. She's coming back to court on another day. She knows it's her mom who made the call. And am I ordering the two of them back in a vehicle, home? Our Supreme Court has noted that the increased threat to victims of domestic violence in their home is a result of the pandemic. And the Supreme Court has gone as far as extending PPO termination dates automatically to recognize that, especially in the pandemic, we don't want situations where victim and perpetrator of domestic violence are in a hot box together. In deciding on detention awaiting disposition, the court noted themes that run through the family history of mother and daughter. Violence with mother as the victim. Mother at times appropriately trying to hold her daughter accountable and then not following through. This court notes as an aside that mother has herself removed Ayanna from the home after violence for a cool-down period on more than one occasion. And mother, at least times in the crazy years, believed that long-term residential care was in her daughter's interests. That hearing was 2 hours long. She was not detained because she didn't turn her homework in. She was detained because I found her to be a threat of harm to her mother based on everything I knew. So that was the detention decision. So we draw another line. The court scheduled the matter for amended disposition. And in plain talk, to me, that means what we're doing isn't working. What adjustments can we make here? And the purpose of juvenile justice is rehabilitation. Every time I take the bench, I'm trying to find a sweet spot. Not too light, not too harsh so that we lose them and turn them off. That spot where we're identifying the problem, we're interrupting the situation with the right tools so that when mother and daughter reunite, because the goal is reunification, when they reunite, they do so safely. Mother's safe in the home, Ayanna's safe in the home, they're communicating in a way that works. It's not this cycle of conflict, verbal argument, physical argument, react, conflict, verbal argument, physical argument, react. We have to interrupt that. So the purpose of the amended disposition is to interrupt it. What do we try now? We tried intensive probation. That failed miserably within approximately 11 days. So what is a good next plan? The amended disposition hearing was held on June 4th. This court carefully considered at that hearing, again, the statements of the parties, all the information that it had access to, the whole history, the violence, the thefts, the incorrigibility, the prior attempts at treatment and intervention, the CPS action, the casework reports, the letters presented on her behalf, the out-of-home screening committee report. I had an updated recommendation from casework at that hearing, and I had an updated out-of-home screening committee report. Everybody stopped what they were doing, said, okay, with this new development, do we still think the same thing? And we held the hearing on June 4th. This family needs help. This court's goal is that Ayanna receive what she needs so that she and her mom can reunite, repaired as individuals and as a family. What they have been doing from 2016 on has not worked. The goal is a home environment, safe, stable, healthy communication. And I hopefully we all have the same goal. Hopefully that's a fact we can agree on. That when they are together again under that roof, the odds of success have been increased because of the work mom has done on herself and the work that Ayanna has done on herself. She is currently in a program on a Children's Village order because of the domestic violence charge and the theft charge with the purpose of rehabilitation. This court ordered that she be placed on that order where she could be screened so we know what program fits. It would consider her high-risk behaviors, her violent and mental health history, her criminal behavior, and her educational needs. And importantly, a strong component is I'm ordering, every time I touch this file, I'm ordering parent education. That's how we get here today. A request for an early review hearing was made on Ayanna's behalf, and the parties are here, perhaps not completely ready to proceed in light of the fact that there was such a short period of time in between the request for the hearing, the grant of the hearing, and today. I want to make sure everyone has a chance to go over all the reports. So what I have is a psychological report that was done pursuant to court order on both mom and Ayanna. So I want to give the attorneys, everybody an opportunity to review that. I have the adjourned hearing report from casework. I want to give everybody an opportunity to review that. I have the Oakland County Children's Village report that gives me real specific information in terms of where she is. She's currently stage 2 out of 5 in her program, that type of thing. So I want to give everyone an opportunity to see all those, because you have to be dying to see those. On behalf of Ayanna, Mr. Biernat, right, you've got, I mean, I'm not being sarcastic. You do really want to know how she's doing, don't you?
Of course, Judge.
Okay, so I'm going to take a break, give you an opportunity to review the psych, the court report, and then what's titled the adjourned hearing report, and you have an opportunity to talk about those with your client. Then I'll start the review hearing. I'll hear from casework. If there's anything, I'll make the record in terms of what I see in the report. If anything needs to be added, I'll hear it. I want, is somebody here from TAG? Thank you, ma'am. I'm going to go over what I see in the report and then allow you to amend it if that's appropriate. The psych, I'll at least take a look at the findings. You'll have an opportunity to ask those providers any questions you have about the programming, how she's doing in the programming, if she's engaged, if she's benefiting, all that type of thing, which hopefully will be reflected. I've read them all, so it's reflected in the reports, but I'll give you a chance to go over that. Then, on your client's behalf, you can make whatever request you feel is appropriate in terms of, should I change the disposition? Should I leave her and let her succeed at this program? She's begun a therapeutic program. If I remove her from it now, I'm interrupting it before it's finished. You may have good reasons for me that you think for me to do that, to interrupt the therapeutic process. You're going to have to make a strong argument. When she is exactly where I think she's supposed to be, and she's doing well, I'll hear you, but I can't fathom why I would sabotage her by changing that. Take a look at the reports. I'll give you an opportunity to talk to your client. Okay?
Judge, if I may, we did subpoena her teacher and IEP coordinator from Groves.
Right.
Would the court be open to allowing her to testify today?
Well, it's not an evidentiary hearing, so I wasn't going to be taking testimony from anyone. It's not an evidentiary hearing. I think you requested a review hearing, a dispositional review hearing under Rule 3.945. So the court conducts periodic hearings to review the dispositional orders. It was set for September, but you asked for an early one, and I'm absolutely fine with that. The victim has a right to make a statement at the hearing or submit a written statement for use at the hearing or both. So we'll hear from mom as the victim if she wants to be heard. It's not a full evidentiary hearing, though, where there's witness testimony. That's just not what a review hearing is. Tell me make an offer of proof. How could Ms. Tarpey educate me on how she's doing in her current placement in Children's Village?
Well, Judge, just as you went through the history of the case, I think it's pertinent that we hear from her teacher as to how she was doing prior to being placed and how she would do if she was released, and the services and accommodations that are required under the IEP would be provided to her if she was released back to the home. And I think
we will absolutely hear from the program in terms of how whether her educational needs are able to be met in that setting, are not able to be met in the setting, how they're being met. So the purpose of a review hearing is she's in the program. You filed a motion for reconsideration on other issues, and you'll get a ruling on that timely. Faster than timely, actually. You asked for accelerated, and I'm going to give you an accelerated ruling. The purpose of this review hearing, though, is how's she doing in her current placement? Should she continue in that current placement, or should I send her home and fashion a different plan? So if you could make an offer of proof, how would Ms. Tarpey help me in that regard?
Your Honor, I'd like to add, the court took a good amount of time going over the history of this case.
Yes.
The court limited the information that was made available to the public in reviewing the progress notes from Ms. Giro. There is a very lengthy statement from the instructor, my client's teacher, who knows my client very well, that would be instrumental to the hearing.
I've reviewed her statement. It came up at the violation of probation hearing. Council has filed a motion for reconsideration with regard to the violation of probation, and that's a separate matter. Are you standing to make an offer of proof as to why I should hear Ms. Tarpey on how she's doing in her tag placement. When's the last time Ms. Tarpey has had contact with Diana?
How could she have had contact? My
I'm
client is in
asking you,
detention.
when is the last time that Ms. Tarpey has had contact?
I'm asking the court, my client is in detention. How
Right.
on earth could the school have contact?
Ma'am, I'm
My client is
asking-
regressing in detention.
So the answer is what? The
I
last
don't-
time? You don't know?
She went into
Okay.
detention on May 14th.
Ms. Tarpey's testimony respectfully doesn't help me in terms of the review hearing. The piece that I'm doing today, which is she's in her program, you'll have an opportunity to ask the placement any questions that you
Your Honor,
want. Ma'am, don't interrupt me. You'll have an opportunity to ask the placement any questions that you wish about how her educational needs are being met. I want to know how her educational needs are being met as well. That's the review hearing, but it doesn't require testimony. You didn't ask for an evidentiary hearing, you're not entitled to an evidentiary hearing, and it wouldn't make sense to do one. I'm respectfully not allowing witnesses to be subpoenaed and testify to the prior issues. Absolutely, I'm going to review. What are her educational needs? How are they being met in her placement? Can her needs be met? I want to hear all that.
Your Honor, Ms.
I'm going to
Tarpey-
pass, okay, ma'am, I'm going to pass this matter to allow you folks an opportunity to get caught up in terms of what has been happening since she went into the program. I'm going to review them again as well, and then we'll have the review hearing to see if I should continue her in her therapeutic setting or return her home with some other conditions. You'll be heard on that. And we're going to hear from the folks who know from June 4th on what's been going on with this young lady. But let me give you an opportunity to go over the reports with your client.
Your Honor,
Okay?
I would like to make a record though.
Go
The
ahead.
best person to know about my client's educational needs is not anyone from Children's Village. It's not the prosecutor, it's not this court. It is Ms. Tarpey.
Okay,
She is
thank
my
you.
client's instructor. I want that on the record.
It's on the record. Thank you, ma'am. Ms. Tarpey was available to testify at the violation of probation hearing. You, Mr. Prosecutor, opted not to call her, and Ayana's attorney opted not to call her, correct?
That's correct, Your Honor.
Thank you, sir. All right, so let me pass it, go over the reports, and then tell me what is the relief that you're requesting. If you're requesting return home, I want an update from everybody, okay?
Court is in recess, all rise.
And I'm going to please ask that the case be recalled.
Recalling case number 2019-878-766DL in the matter of Ayana Odom Factor.
Thank you. May I have appearances again so it makes a good record?
Good morning, Your
Counsel?
Honor. Justin Chmielewski, Assistant Prosecuting Attorney on behalf of the people.
Thank you.
Patricia Derrick, on behalf of the Your Honor.
Ma'am, sir?
For the record, John Burnett on behalf of Ms. Odo Coxford.
Thank you, sir.
Good
Ma'am?
morning, Your Honor. Simon Cleo on behalf of Ayana Odom Foxford.
Thank you very much. All right, do we have, let me get my name together here, so I have all the reports. I've got the psychological report. I've got the court report from Children's Village, and that's the first person I'd please like to hear from. And then I've got the adjourned here report as well. So I'm going to remove the distractions because those are the relevant documents for a review hearing. Counsel, have you had an opportunity, and by counsel, pardon me, I mean Mr. Burnett, have you had an opportunity to talk to your client?
Yes, Your Honor.
Is she still requesting, after review of the recommendations, a change of disposition to not complete the TAG program?
That is correct, Judge.
Okay, thank you, sir. So could I hear a representative from the program? Could you come forward? And we'll keep you distance, but we'll get you by a mic. So how could we do this?
Your Honor, I'm comfortable if she would like to use.
Are you okay, since you're in a mask, are you guys okay with using the podium then?
Yeah.
With everybody masked, okay. Could you please approach the podium, whoever is gonna,
I'll go first.
please? And could you state your name for the record?
That's Patricia Wright, Case Coordinator, Children's Village.
Thank you, ma'am. All right, and are you the author of the report that I've got that is dated 7/17/20?
It is me and my coworker.
Okay, you both are authors of we're talking about a 2-page report that updates me.
Correct.
Okay, So what I'm gonna please do, if you would stay right there available, I'm gonna go through what I think you are trying to communicate with me through this report, and then I'm gonna give the attorneys an opportunity to ask any clarifying questions that they might have, and I may have questions as well, okay? So what I believe is that you are communicating to me that she was screened and recommended for the Transitions Academy for Girls, which we all call TAG on the regular. So she's in the Transitions Academy for Girls. She is currently stage 2 out of a stage 5 program, that her behaviors to date have been good, that she has adjusted well, that she's advancing in the program, she's making progress towards completion of goals and completion of criteria each week. She's been observed working on her goals, completing assignments, and asking for help when needed. She's also doing a journal series entitled What Got Me Here, and is currently working on the individual change plan in her journal. Appropriate with peers, is being open and honest in her responses and discussions. And I'm not reading it word for word, I'm going over what's jumping out at me, and then you'll add what you think I missed or need to emphasize. In terms of therapeutic goals, she's been engaged and open. She's established rapport with her clinician. She's expressed wanting to improve her time management, managing her depression, improving her self-esteem, and reducing impulsivity, which can lead to poor decision-making. She has been addressing self-esteem and been opening up about her issues and concerns. I guess I'm going to interrupt myself right now and say this to you, Ayanna. This is when I said this morning it's going to get worse before it gets better, this is the better part, from my perspective. This is you, I'm getting a report on how you're doing now, and what you're doing with what's in your control, okay? So this is the better part. When I'm reading words like engaged and open, establishing rapport, wanting to improve certain things, addressing things, opening up, these are the words I'm looking for. All right, she had an initial psychiatric evaluation. Some medication was recommended. This young lady reports that her medication has been helpful and no noted side effects, and she's medication compliant. Mother has participated in TAG to the extent that she's expected to. It does say that mom has appeared hesitant to fully engage in the therapeutic process, but in terms of her contact with Ayanna, they have both, when it's the two of them, they've appeared to engage well, have discussed previous issues regarding authority and respect, and while these issues have begun to be explored, they have not yet been resolved. In terms of educational, and you're going to have to answer questions, and I want to hear the answers to them as much as anybody in this room does. She's currently enrolled in school through the Waterford School District. Because of COVID, there wasn't in-person school. However, there were homework packets like everyone was getting for kids to work on and complete. Summer school just started, it looks like. TAG staff are available to help Ayanna work through school packets, and Ayanna's teachers are available for consultation if needed. When you say Ayanna's teachers are available for consultation, you mean the ones from the Waterford schools that provide the educational environment?
That's correct, Your Honor.
Thank you. In terms of community involvement, she has been selected to participate in the Teacher's Pet Program, and she's working with rescue dogs to assist them with training and preparing the dogs for adoption. I want to talk more about that too, because I want to understand that. In terms of the permanency plan is for this young lady to return home to her mother. In terms of your recommendation, you say at the time of this report, the prognosis for her to successfully complete the TAG program appears good. She's made steady progress in the program, both behaviorally and therapeutically. Mother is participating in the treatment, including attending therapy, visitation, and cooperating. Mother is very supportive of her daughter's treatment. Are you recommending that she remain in TAG through completion?
Your Honor, as with all residents, we do recommend that they stay and get the benefit from the program. She's only at stage 2. She still has 3 more stages to go before completion, and since being there, she is working on the journals and doing well, and each journal represents each stage of the program, with the final one being the reentry process. So
Okay,
we-
so, oh, I'm sorry, I thought you were,
I'm-
okay. Not to oversimplify it, but when I look at a program, a therapeutic program that has a mental health component like this does, I believe it has a beginning, a middle, and an end, and that there are social science reasons that it's structured the way that it is. Am I being oversimplistic?
No, no.
Do you think she would benefit from committing to this, the beginning, the middle, and the end, and seeing it through?
Yes.
When I read this report, this is as good as it gets as far as a first review hearing. Normally, I have more time that's passed, so I kind of have more of a sense of where we're headed, but this is excellent. She is on point, she is doing well, she is engaged. Okay. Do you have, Mr. Prosecutor, any questions for this representative?
No, Your Honor, no question.
Thank you, sir. On behalf of Ayanna, any questions for the representative from TAG?
Oh, yeah, just a couple questions.
Thank you.
Good morning, Ms. Wright. Nice to see you again. We met briefly last week. Mr. Brennan and I met with you. Thank you for coming this morning. So, can you tell me what is your educational background?
What's the relevance of that in the sense that she is offering testimony in support of how this young lady has done in the program thus far?
I think because if she's making a recommendation that my client stay there, she's got to have some level of professional education and professional experience to come and make that recommendation.
You can briefly answer the question what your educational background is, but that's really not, I'm not going to go far on this. Go ahead. If you don't mind, you can briefly answer.
Bachelor of Science, Health and Human Resources.
Okay, how long have you been with Children's Village?
I've been with the village for 30 years.
Okay, and what capacity are you currently in?
I'm the case coordinator
How long have you been the case coordinator?
for over 20 years.
So you were the case coordinator assigned to my client when she entered the program? Okay. And overall, your position as to my client is that she's in compliance with the program?
Yes.
Okay. Were you aware, when she was assigned to you, were you aware of her prior history?
I was.
Okay. And were you aware of her prior medical diagnosis?
I was.
Were you aware of her prior mental health diagnosis?
I was.
Okay, so in your statement, when you put that she was diagnosed with ADHD, you already knew she had ADHD coming into the program, is that correct?
I just need to back up because there was 2 of us on this report.
Okay.
And I am not the clinician or the therapist
Okay.
or the psychiatrist.
Okay,
So that information would come from them. So I can't answer on a clinical
no
basis.
worries.
Okay, thank
In
you.
your capacity as a caseworker, were you aware that Ms. Odom Foxworth had been previously diagnosed with ADHD?
I was based on the file.
And to your knowledge, based on the file, was she treating with her healthcare providers prior to entering Children's Village?
To the best of my knowledge, yes.
She wasn't compliant.
Yes.
Okay, and were you aware of the therapy service that her mother had set up for her?
Not in detail, no.
Okay, were you aware that she was receiving 2 times a week in-home therapy sessions prior to entering Children's Village?
I believe my mother reported that to me.
So she was getting 2 sessions a week. You know that she was getting 2 sessions a week?
I do not know that. I just know that my mother reported that.
Counsel, she's here for a limited purpose. She is here to educate us on how this young lady has done since I signed the order placing her. She's not here to give you the case history or be cross-examined in terms of the case history. She can tell you about TAG, and she can tell you how she's been doing since she started interacting with the young lady.
I need the court to be aware of what my client is being deprived of within the facility. So that's why this background information is important for the record.
You can
I'm trying
ask
to make
her
a
what
record.
she's done, what she is being provided in the program. I have been here for the other hearings. I have had the opportunity and took the opportunity to review the entire social and legal file. I have done that.
Oh,
So I don't need you to re-educate me in terms of the history and what was happening at home prior to. I'm prepared.
I trust Your Honor completely. I just need my
Okay,
record.
so Well, let's figure out what's best for Ayanna today.
Oh, of course.
Okay, so in terms of, I'm not here to just make a record.
Right.
I'm here to hold a hearing and make decisions.
Absolutely.
Okay, so do you have any additional questions, information that this lady would have with regard to the TAG program?
With regards to the TAG program, does the TAG program provide my client with family therapy?
Yes.
And how often is that family therapy?
It would depend on the case, and she is receiving it right now.
How many instances of family therapy has my client had since May 14th to today?
I would have the therapist speak on that.
Okay,
Your Honor.
could you state your name for the record?
Sunitha Pulipotl, Your Honor.
Thank you, ma'am. Can you answer that question?
Yes, I can. So since Ayanna started at TAG June 8th, I can answer since that time because May 14th is when she was in detention, and I was not the clinician for that since it's a different building. But since she has entered TAG, we've had 3 family sessions. Normally, it's twice a month. The first session is typically to get an idea of what they want to work on, and then it's twice a month moving forward from there.
Thank you.
Did you have an opportunity to review Ms. Odom Foxworth's file prior from the time period of May 14th to June 8th?
I did.
And did that file identify family therapy sessions?
They don't do family therapy in detention.
So she didn't have any family therapy sessions?
Counsel, not relevant for the purposes of this hearing. You folks set the parameters. And it's a review hearing so that I can make a determination whether the programming that's currently in place continues to be appropriate. So respectfully, what happened during the days that she was detained when the court found her to be a threat of harm and did not return her home is not relevant to how are we doing now and what should we be doing next. So I'm not going to have you answer that question.
Your Honor, the court needs...
Ma'am, I'm not going to have her answer that question. Anything that you want to know about TAG, these ladies have more information than I do. So if you have any questions for them, now's your time to ask them.
I have a few questions, just briefly. How many levels are involved in the TAG program?
5 stages.
5 stages? And what do they involve? How does a participant move from one stage to another?
There's criteria that they work on weekly. There's also goals that they work on in addition to journal.
Okay, and what level is Ayanna on today?
She's a stage 2, step 2.
Okay, and so going
Your Honor,
through,
may I just interrupt for a second? Can I have you step closer to the mic?
So that we're capturing, yeah, this is challenging. Thank you. So
I apologize.
we'll do the best we can. And you've got to keep your voice up because the mic that's in you is there.
I'm sorry, Judge. So she's at level 2, and you said step 2?
Yes, each stage has steps to them. Every stage has 4 steps except stage 5 has 2. Or stage 2 has 5 steps, I'm sorry.
When do you anticipate that she will graduate or move to step 3?
In approximately 4 weeks if she earns her levels every week on time.
So each level takes approximately 2 months?
Each stage
I'm
would
sorry, each stage?
approximately take a month.
So when do you anticipate her completing the program and being allowed to return back to the community?
Are you asking for a specific date or an approximate time?
Approximately.
I want to say approximately 3.5 months.
From today?
Yes.
Does she, pardon me for
I'm sorry,
interrupting, just
go
so I
ahead.
know, does she have a certain amount of control over that? If she's applied, engaged, and benefiting, it goes, I would assume,
So
more
as long
quickly?
as she is completing everything that she needs to and engaging appropriately, she earns her level every week. And so far she has, since she started the program, she has not missed a single level.
Thank you, ma'am. I didn't mean to interrupt your
Oh, no,
question.
Judge.
Go ahead, sir.
Thank you. Would she be allowed at this point to have day passes or weekend passes to re-engage with the community and become reaccustomed to being at home?
When do they, at what point
I'm
are you
sorry.
open to them earning passes?
When they become a stage 4 is when they start. And unfortunately, we haven't been able to begun the whole pass process. due to the COVID. However, visitations are taking place. So mother is coming every Monday to visit, so she's establishing that rapport and being able to visit with her daughter for an hour and a half.
And she's not at the point where she'd be eligible for home pass yet, correct?
She is eligible.
All right, I thought you said stage 4. Do you mean stage 4 of?
Stage 4 for weekend passes.
For the weekend,
Thank you. Okay, so
So she
mom
has-
can come there now.
correct.
COVID is challenging us in terms of release to the home environment.
Correct.
And I think I included in the order intentionally, tether when she first returns home, and you would honor that as well. Okay, meaning for like the overnights and the weekends, that didn't, okay.
So she's getting day passes now.
She is eligible, but because of the governor's orders, we are not allowed to do the home passes right now. So we are implementing that. As soon as we hear something, we can let the family know.
So mom can't come and physically be in,
Mom is coming every Monday for visitation.
I'm hearing you say mom can come there,
Mhm.
face to face.
okay, face to
She
face.
can't go to the home,
Okay.
face to face, yes.
Correct.
Thank you.
And in terms of therapy, how often does she receive therapy? I'm sorry.
So per the assessments, Ayanna is receiving therapy every other week. Normally when they're in the program in the beginning, I personally just like to meet with them weekly just to get a better understanding of them.
So are you her therapist then?
Yes, I am.
And so how often do you see her?
Right now, it's every other week, and Ayanna does have an opportunity to sign up on a board in TAG if she would like to see me sooner, which I check every day, and if I do, I typically see them that day or the day after.
So she has therapy sessions twice a month.
Yes, but usually I do a little bit more anyway.
How long are those sessions?
It varies depending on the purpose of the session. If it's a medication update, it could be a little bit shorter if that's it, but typically between 30 minutes to an hour.
So there's no standard therapeutic program that at TAG that you would abide by those guidelines, say you go and see her for an hour and there's some progress report submitted after each session?
I don't know if I'm understanding.
Do you submit a report after each session detailing how Grace is doing?
Not a report, we have clinical notes, yes.
Okay, are those available?
Not that I'm aware of. I would have to check with my supervisors and administration how that process works.
Okay, and so you've seen her since June, she started the program June 14th?
June 8th.
June 8th, so she's been in the program a little over a month, or 6 weeks? And before that, she was in detention for a month?
I believe so.
You're not sure?
I don't have the exact dates.
When someone's placed in detention at Children's Village, are they receiving any therapy at all?
This is not the folks that you would ask that question to, and that's not what the review hearing is for. You asked under the court rule for a review hearing of her current last dispositional order, and whether that order should stand or I should make adjustments. These folks, they got a referral, they got a child's name and case file, and they started working with the young lady.
Okay, can I ask, so you don't work in detention at all?
No, I work in the TAC building.
Okay, so you didn't have any contact with Grace prior to her coming to TAG?
Only once they're ordered and they arrive at the building do I begin working with them.
Can I ask this briefly, who's in charge of the detention center? Who's the coordinator?
Is it a case coordinator you're asking about? Or?
I don't know, who's in charge of detention at Children's Village? There's gotta be somebody who's
You may
supervising.
not know.
That's a,
If you
I don't know that I
that's
know.
fine, yeah,
I don't know how to answer that.
okay.
Is there a difference between TAG and detention?
Yes,
What's the
TAG is a
difference?
treatment program. Detention is temporary placement until a decision's made.
Thank you. Detention is a temporary placement until,
Until disposition to
Thank you.
determine what happens with their case.
Thank you, ma'am.
So prior to coming to TAG, just to clarify, you're not sure what happened, whether or not she received any services, any mental health, any therapy, anything?
I can't speak to that, 'cause I'm
Okay.
not the clinician in that building.
Thank you.
All right, thank you very much. Mr. Prosecutor, any questions for these witnesses
No
based on what
questions,
you
Your Honor.
heard?
Thank you.
Thank you, sir. All right, with regard to casework, who would like to speak on behalf of casework? Thank you. Could you state your name on the record, ma'am?
Good afternoon, Your Honor. Ashley Bishop.
Thank you, ma'am. You provided a written report to the court to update me. A lot of it looks like it's information that you captured, correct me if I'm wrong, but that you captured from the TAG report. You indicate, from your perspective, she's adjusted well to programming, has not missed a level, has not had any behavioral issues, and is reportedly engaged. She earned star resident for the week of July 6th. Mrs. Odom reports that Ayanna has been more self-aware, optimistic about the future and returning home, and has been more serious and thoughtful, that she's engaged in individual therapy, that both are engaged in progressing in treatment, that they're working on their communication, expectations, and respect. She's got a journaling project that she works on. Mom was referred to the parent project back in April, but because of, I'm assuming because of the pandemic,
Correct.
that's not happening right now.
Correct. I did speak with the two workers that are in charge of that, Miss Amanda Alvin and Joe Hall. They will be meeting this week to set a date for the next session. So
Okay.
Mom will be a part of that.
Thank you very much.
Yes.
You informed me on in-person visitation, which began again just recently, June 29th, but prior to that it was Zoom, how most folks are doing things. In terms of school status, are you comfortable that the program is aware of her IEP?
Yes, so she had 504 plan prior to getting into Children's Village. Now what the Children's Village does is they request records from her
Okay.
previous school. So we did have an orientation CCP meeting on June 24th, collaborative case planning meeting, where that was discussed. Because of the COVID, she has not been retested, or a reevaluation has not been done yet.
Okay.
Once that is available, she will get reevaluated for that.
Okay.
Yes.
Right now, if she was in need of accommodations and supports, and the Waterford teachers who are assigned to work with the girls that are in TAG, are they available to provide those? Is it the Waterford School District's then responsibility to provide accommodation support? So more one-on-one time perhaps, or more time to complete an assignment?
She is, I did speak with Ms. Wright to clarify that prior to coming back on the record, and she is able to meet with teachers via Zoom. She did have an IEP since January of 2019.
Right.
So the 504 plan was initial, and then she had her individualized education plan. So that will be, once Waterford School Districts allows those to, reevaluations to take place, she will get that done.
So she'll get a reeval on her IEP, so that everybody can sit around a table and say, is this still the plan?
Correct.
But are her educational needs being met in terms of extended time and access to one-on-one, whether it's by Zoom or whatever, are they being met now?
I would have to refer specifically to the Children's Village School and the teachers that are working with her. I know that we discussed this at the orientation. We have a Oakland Schools coordinator, Ms. Phillips, who sits in on those.
Okay.
She's been in communication with Mother, specifically about when she's released from TAG and making sure that her accommodations are met. I have not heard that Ayanna has made any comments that it hasn't been being met or she hasn't been giving the time, but I would have to refer to specifically who's working with her.
The meeting that you referred to, the CCP,
Yes.
was
Yes.
a representative of Oakland Schools at that
Yes.
meeting?
Yes.
So there was a representative from the schools who's aware of her prior 504 and her current
Yes,
IEP?
correct.
Thank you, ma'am. All right. And at the time of your report writing, you didn't have a psychological, you've received it now?
I did.
Have you had an opportunity to review it?
I have.
Thank you, ma'am. And do you find it to be consistent with the recommendations and overall findings from TAG and from casework services, if you know what I'm saying? Is the recommendation in the site consistent?
Correct, yes.
Okay. You are recommending that it would be in her best interest to remain in the TAG program in order to continue to work on her individual objectives, her mental health treatment goals, and continue to address her and her mom's relational strains in a therapeutic setting.
That is correct.
Do you have any questions for this witness, sir?
No questions, Your Honor, thank you.
Thank you, sir. Do you have questions for this witness, ma'am, or sir?
I'm sorry, Judge, just a moment.
Go ahead.
When did you become Grace's probation officer?
I know her as Ayanna. I think the court record knows her as Ayanna.
I'm sorry, Judge, in terms of the press, though, I mean, if they're going to be reporting, and I believe there's going to be a substantial amount, I would prefer that they use that, and I'm comfortable using it because when speaking to the press, that's the name I use. I don't know if that's inappropriate, Judge.
It's not inappropriate for you, but this is a public hearing, and I'm going to refer to the participants by their legal names. That's how I've known these folks all along, and the public there's a public interest in understanding the process, and I have no problem with, I've asked media and actually ordered media their faces can't be recorded. My face can be. I hate having my picture taken. Didn't want a bridal shower, but I'm a public figure, so my picture is being taken. I'm not having mother or daughter's picture being taken, but they are who they are.
But her name won't be disclosed.
Nobody's made a request that it shouldn't be. This is a
Well,
public
I'd
hearing.
like to make that
If it weren't
request.
for, well, do
She's a
it in
juvenile.
writing and give me a basis then,
Okay.
counsel, respectfully. Did you have additional questions for this witness?
I'm sorry, Judge, yes. You became Ayanna's probation officer, well, when exactly?
So when Ayanna was referred to the court on the domestic violence and the larceny from a building, I was assigned her case. I was actually looking back at my notes to see specifically when she was assigned to me. I believe it was in March. Then a social history report and interview is conducted. So I did conduct a social history with Ayanna and her mother. This took place via Zoom. And I was not at that time her probation officer because she was not on a probationary order. She was being heard before the court on those two charges that I had just named. So as Your Honor had gone through the description, we did have that dispositional hearing where she was placed on intensive probation. And so at that time she was transferred.
I guess my question is when do you get assigned the case? You get assigned the case before the adjudication, right?
Our supervisor, we get assigned the case pre-adjudication.
You do an intake prior to adjudication.
We do not begin working with the family until after the child is adjudicated, or after the child has their pre-trial.
You didn't speak to the family or to the Ayanna prior to the adjudication?
At that time, she has not been found either, has not entered a no contest plea, or she's not been found adjudicated, so we're not involved at that time.
Okay, so when do you first meet Ayanna?
After she is seen for an initial pre-trial in front of the judge, we do conduct a social history interview with the family. And I can get that specific date for you.
Okay, and so you said before March. Is that right?
1 second, let me get the date for you.
And I'm really looking for testimony, if you're seeking it, on what's in her best interest today, should the order be changed, why or why not? That's where, we're reviewing the last dispositional order.
I appreciate that, Judge.
Okay, because right now you're before the first dispositional order.
I understand that, Judge, but the court had an opportunity to review the file from 2017 and make a record of it.
Everybody had an opportunity to do that.
And now I'd like to try to present a record and ask questions as to how long she's been on the case, why Ms. Guru isn't here, the intensive probation officer who filed a violation, how then she became,
Those are some procedural questions I might be able to help you with. When somebody's on intensive probation, they have one caseworker. When somebody's on a Children's Village order, they have another. Am I wrong?
no, I understand that, Judge, but I'm curious as to how Ms. Guru, who was her probation officer for 7 days, essentially violated her. And maybe Miss, I'm sorry, what was your name now?
Wait, no, go ahead. You said you're curious, Judge. No, she's good right now. Go ahead.
I
You
was
said
just
you're curious, Judge.
How, when the worker, and I wish Ms. Guru was here, I was hoping she would testify.
There's absolutely no reason for Mr. Rivera.
I understand that, Judge.
You were confused about how casework assignments are made. I'm happy to clarify that. She's not here because Ayanna isn't on intensive probation anymore. So when when her dispositional plan is intensive probation, it's Mr. Rue. When Ayanna's plan changes and it's treatment now, rehabilitative treatment, mental health services, she has a different caseworker. Correct me if I'm wrong.
That is correct, Your Honor. And to be specific, the social history was conducted on April 6th
Okay,
via Zoom.
so you were her probation officer until April 21st?
That is correct.
And then on April 21st, Ms. Guru became her officer?
That is correct.
And then she filed a violation on May 5th.
Are we answering questions in regards to?
I'm asking you a question.
She didn't file a
I'm asking you just
violation.
a question.
Right?
I do not.
She wasn't her probation officer when she was on intensive probation.
I understand that. Judge,
Okay.
but if I'm someone's probation officer, I assume I know what's going on with the case, despite the fact that my colleague, I assume you work in the same building, has taken over the case and has filed a violation. I mean,
Is your expectation that I know what's happening in every other family judge's file in this building? You would be sorely disappointed. I don't
Judge, I don't
have.
question this court at all. All I'm saying is, can you give me some information as to how this occurred?
I will if you ask me a specific question.
Okay.
Go ahead.
When was the last time you dealt with this file?
Is there a more specific question? I mean, I
Okay,
just
you were
don't.
taken off the case on when she was adjudicated on April 21st.
When she was placed on intensive probation.
Okay.
Yes.
She was adjudicated and the dispo happened on the same date. Am I mistaken?
She had, Your Honor, she had pled no.
You are mistaken.
Yeah.
Okay.
Okay.
So the adjudication, so the disposition was on April 21st.
Correct.
The disposition, the first dispositional hearing was on the 21st.
So at that point, you're off the case.
Once the judge ordered her on intensive probation, that is correct, I was off the case.
And then you come back on the case.
I come back on the case during the second dispositional hearing when judge orders her to a CV program.
So you didn't have any say at all or recommendation as to whether or not she should be placed in a long-term placement?
When we had that initial disposition, as the judge had stated previously, I had screened her case before the out-of-home screening committee, and at that time, the recommendation was for a Children's Village program. She was then placed on intensive probation. Intensive probation then found the violation, and the judge ordered her to go to Children's Village. And the matter was also rescreened a second time.
Was that unusual for somebody who had never been adjudicated prior?
It was not considering her past.
So you would send someone to placement on a misdemeanor adjudication?
It was not my recommendation.
You said you recommended placement.
It was the out-of-home screening committee's recommendation that we recommend as casework. That's why we present the case in front of the out-of-home screening committee.
You wanted her to go to placement prior to her pleading, or after she pled and was adjudicated, you asked the judge to send her to placement?
That was the recommendation at that time.
Okay, so your position hasn't changed?
My position has not changed. I believe it's in her best benefit to be where she's at currently.
And why is that?
Because she's receiving the mental health treatment she needs. Her and mom have made significant progress, Your Honor. I've had conversations with mom. One thing that stood out to me is that she reported.
I'm sorry, just
No, go ahead, let her talk.
Okay.
We want to know how things are going.
Okay,
Let's
Judge,
go.
I'm sorry.
Please, ma'am.
I just want to note that prior to Ayanna being placed in Children's Village, mom reported that they were receiving hardly a family therapy component in the community. That was mother's words. I will say that they've made significant progress just in speaking with Ms. Philipattle. And in speaking with mom, she reports that they've been able to communicate much better. She is more self-aware, she's more serious, she's more thoughtful, and her and mom have made significant progress. Mom reports they're communicating, they're talking through issues.
Do you think that therapy twice a month at a half-hour session is adequate or substantial?
I don't have any clinical background as far as that. That's the recommendation from the clinician.
You just spoke to her mental health therapy and whether or not it was adequate prior to placement.
I'm speaking about what mom had reported to me, also speaking on what Ms. Legato has reported, the clinician.
So now she's been in placement for 6 weeks, and prior to that, detention for a month. Is that right?
Are you speaking of when she was detained prior to that second dispositional hearing?
Yes.
The exact time frame, it was approximately a month. that
If
she
you
was
weren't
detained.
her caseworker at that time, I'm not
Yeah,
gonna make you get the calendar out.
I was not her caseworker at that time.
So what is... So let me just ask you, and then I'll stop. I'm sure I'm coming here, but do you feel that she is a safety risk to herself, to others, or to the community today, as we stand here today?
I do.
Why?
Based on her history and everything that Judge had stated previously, she has a long history with our courts. When I had first met with Mother, she reported to me that her behaviors have continued, if not have gotten worse.
She has a long history. She's been adjudicated of 2 misdemeanors in her, that's all that's on her record, is that correct?
So can you ask me that question one more time?
Her juvenile record contains 2 misdemeanor adjudications.
The domestic violence and the larceny in the building, is that what you're referring to? Yes.
So when you say a long history, you mean 2 misdemeanor adjudications?
I mean a long history of professionals reporting that she is assaultive towards her mother, including Child Protective Services, youth assistants, her therapist.
Did she have any issues while on intensive probation?
I was not the caseworker at that time.
Okay, so you only know what's happened since she's been placed in detention?
In Children's Village TAG, yes.
Did you know what was going on during the detention period?
I was not her caseworker at that time.
Okay, so when she went into detention, she still had Ms. Guru?
Until that second dispositional hearing,
Okay,
correct?
okay, I'm sorry.
Yeah, if that
All right.
clarifies that.
Okay, just a moment, Judge.
Thank you, sir.
I don't have anything further, thank you.
Thank you, sir. Thank you, ma'am.
Thank you.
And with regard to the psychological, has everybody had a chance to review the psychological, Mr. Prosecutor?
I have, Your Honor.
Thank you, sir. And counsel for Ayanna, have you had a chance to review the psychological?
Yes, Your Honor.
I have not had the time to spend the amount of time that I normally would spend with it. I read it, but I like to read it and then go back and highlight it. But I am going to capture some of the recommendations in terms of the summary and recommendations from the court-ordered psychological. They do address the ADHD. Records indicate that when she was approximately 9 years of age, she was diagnosed with ADHD. Since that time, she's received various interventions with the school and community related to her mood, acts of physical aggression that were directed mainly towards her mother, and did require police intervention. And then she gives some of the history again that you folks have all heard. In 2017, hospitalized on a mental health order, completed a diversionary program, continued problems with compliance in the diversionary program, and continued court intervention just prior to her court involvement. It does inform me that she had 2 sessions of therapy with Easter Seals. It says after the violation of probation was filed, she completed 2 sessions of family therapy at Easter Seals. A history of stealing electronic devices in response to restriction of her privileges, engaged in sexually inappropriate behavior using the internet, several instances of physical aggression that led to police interventions. She does not have but desires a strong relationship with her biological father, who has historically provided financial support, but has been missing in action during these proceedings. And I added that has been missing in action. The results of the evaluation find that although Mrs. Odom previously requested placement of Ayanna into a treatment program, She currently disagrees with Ayana's placement in Children's Village because she believes they were making progress in treatment and she was not provided enough time to adjust to her online education. Mrs. Odom's current perception that Ayana was placed into a program solely because she was not completing her schoolwork represents a minimization of the aggressive behavior of Ayana that led her to isolate herself in her bedroom and call the mobile crisis unit and request an out-of-home placement of Ayana in April of 2020. It also disregards her previous concerns surrounding Ayana's impulsive and maladaptive behaviors that led her to engage in sexually inappropriate behavior and several instances of theft. While Mrs. Odom presents with parenting insight and knowledge that in part Anaya's impulsive responses are in relation to her diagnosis of ADHD, she lacks insight into how her own response style, tendency to vacillate, and lack of action in a timely manner contributes to the conflicts in her relationship with Ayana. Additionally, Mrs. Odom's distrust may cause her to misperceive and misinterpret the behavior and intentions, and likely has and will continue to hinder her ability to fully engage and benefit from treatment. While Mrs. Odom's knowledge of Ayana's diagnosis provides a base of understanding that can aid her in her ability to help her, she should also be educated on the need for Ayana to develop effective coping mechanisms and not to use her diagnosis and means to justify explained behavior, as this will hinder her growth and independence. While Ayana also believes that she and her mother were making progress in treatment prior to her detention and she would prefer to be placed in her home, Ayana presents with a more open and positive attitude toward her placement than does Mrs. Odom. She displayed the capacity for insight, verbalized her intention to utilize her time, make improvements in her coping skills and behavior. She's formed many appropriate peer relationships, but they're largely through social contacts developed by Mrs. Odom, and Ayana presents as somewhat resentful of her lack of autonomy. People working with Mrs. Odom and Ayana should help them establish appropriate rules and boundaries with this in mind and help Mrs. Odom understand that in part Ayana's behavior is an effort to elicit a response and have her needs met. The recommendation from the psychological that was authored by Kathy Spadafora and is dated the 19th, yesterday, she says she's recommending in terms of the TAG program. In therapy, the impact of the disparity between Anaya's more impulsive response style and the more slow measured response style of her mother should be explored, as it's likely a contributing factor in the conflict. Number two, while Ayana's diagnosis of ADHD is likely a contributing factor to her difficulty completing her schoolwork in the absence of educational supports, it is unlikely, given Ayana's overall cognitive and adaptive abilities, that her ADHD rendered her unable to complete even a minimum of the expected assignments. As such, the other contributing factors to Ayana's failure to comply with the requirements of probation should be explored. Other potential barriers to progress that may be explored are Mrs. Odom's distrust of the motivation of others and her response to feeling a loss of control, as she tends to be an individual who will more passively express her anger through a lack of action. Mrs. Odom should also, in therapy, address why Ayana views her mother to be lacking in progress. She also recommends, in terms of the therapeutic component, that Ayana's desire to have a relationship with her father and her feelings regarding the lack of their relationship and to what level she attributes that to her mother should be explored and hopefully engage and benefit with regard to that point as well. So the psychological doesn't make a specific recommendation, just some treatment recommendations that would be helpful to the folks at TAG. Mr. Prosecutor, what are you recommending, if you wish to take a position?
Your Honor, at this time, I would like to defer my recommendation until such time as the defense has had the opportunity to make their argument.
Okay, thank you, sir. What are you asking as a result of this review hearing in terms of planning today?
Your Honor, we're asking for the release of my client to the care of her mother, and if the court wishes to keep the tether in place on her, that's completely fine. But before the court makes its ruling, I am making a motion under 2.119A1 and asking the court grant permission to allow Catherine Torpey to testify at today's hearing. The court opened the door by reading the record and only select portions of the record. And I think it would be absolutely critical for today's hearing that the court hear testimony from Ms. Torpey. That email that the court read earlier it's a super long email that gives incredible insight
Hang on.
to everyone.
Give me, it's 2.119. 2.119 is motion practice.
And I'm making an oral motion during the
Oh,
hearing.
okay, I thought you were giving me some
No,
legal
just
basis.
an oral motion.
Oh, okay, so are you
to
saying
support-
that I didn't hear testimony from a necessary witness? Or
Yes.
what is your, I don't mean to make your argument for you. Okay, make an offer of proof. She's gonna say what?
She is going to testify. The reason why my client was in court on May 14th and the reason why she was detained is explicitly identified.
What
from
is
the
Ms.
May 5th.
Tarpey gonna say?
Ms. Tarpey is going to testify that for at least 1 month, there were no obligations on any students to do homework. The court asked us, and the court
Ma'am,
said,
hang on.
no,
I'm specifically, wait, you're a lawyer, okay? And I asked you for an offer of proof. An offer of proof is what's the witness going to say if they come in and they go under oath? Because you may get a stipulation. So I need an offer of proof. What would she say? If she were placed under oath, what do you believe she would say? That's different than making an argument. So Ms. Tarpey would tell me what?
there was no homework requirement on the students in her class. Specifically, with students that had disabilities, like my client who had an IEP, there was no structure. The children were held harmless from any of their obligation under the executive order.
Okay, what dates would she say that applied? 1 month you said prior to?
At least up until from the time the school went into shutdown, which was about about March 12th to about April 15th. There was, what was this? This is what the teacher described to me.
Ma'am?
There was,
What, that's
but that's the offer of proof. She's
Here-
going to testify to that.
Okay, so she's going to tell me that
For 1
from
month.
March 12th, now would she be able to inform me about whether she was doing online learning for this when she was suspended for the theft or no? Was that not her teacher when she was suspended from school for the theft? Or do you know?
In November.
When she was suspended for stealing?
So I'm talking about what.
I'm just asking if she'd be able to educate me on that. Was this a kid who did online before when she was suspended? Yeah. If you don't know, it's good.
I don't know.
I appreciate your candor.
Yeah.
All right, so Ms. Tarpey would tell me that from approximately March till April 15th, that she wasn't holding anybody to the strict restrictions of homework and turning things in and that type of thing. That's what her testimony would be. Okay, the original disposition took place on April 21st. So what's 21 minus 15? So that period of time, you're telling me that she would tell me that up till April 15th, she wasn't going to get demerits, wasn't going to get her grades impacted by not doing homework up till April 15th. That's what you just said, correct?
Yeah, I get it. Yeah.
Will you accept that stipulation?
I'll accept that stipulation.
I'll accept that. I'll take that as a stipulated fact. The original disposition, when the young lady was placed on probation and I told her you are on thin ice, was April 21st, was subsequent to that. So I accept your stipulation that Ms. Tarpey recognized that we are in strange times and these kids are under pressure and the teachers are under tremendous pressure as well to try and adapt to this online learning in the middle of a worldwide pandemic. I'll accept that stipulation, so I don't need Ms. Tarpey.
So then, subsequent to that, subsequent from April 15th until my client goes into detention, it's not that much different. There is no, these are reading my notes. There were some development of lessons and activities that the teachers created, with little to no time to prepare for anything. The students could go online, but there was going to be no consequences from the school, no consequences from a teacher, no penalties, no discipline whatsoever for any of the students.
Okay, will you accept that stipulation?
So all of
This argument was made previously. I will accept that stipulation. Here's the consequence. Me. I told, at the very least, get out of bed. I will accept your stipulation that educationally her teacher wasn't going to consequence her for missing homework, not logging on, not going to Google Classroom, not sending her teacher an email, not getting out of bed. I accept that. Her teacher was not going to consequence her for that. I will accept that stipulation. Is there anything else Ms. Tarpey could help me with?
Absolutely. So then the court identified the 1 o'clock to 1:30 tutoring that my client was involved with. So my client then, as she's adjusting during a pandemic to her classroom instruction, which is nowhere near what it was.
You're
prior
making
to-
arguments.
But it's what
That's-
she's testifying.
that's
This is
argument.
This is what she's telling me. So my client participates in her class, which I think runs from, I guess, 12 to 1. That's a class my client is participating in with the support of this IEP instructor, because that is her specific specialty, and she knows my client. She testified to that. And then my client is participating from the 1 to 1:30 tutoring. So my client is participating to the extent that she's able to, given the restrictions of the pandemic. This is why
This is the motion for reconsideration that he filed, or you filed, I don't know who, that is
both
filed,
filed,
and you'll get a ruling on it. This is the violation of probation hearing. It won't help me today to hear from Ms. Tarpey. There's a reason why when I laid out, there's sections to this, and frankly, hang on. This court, if there was never a violation of probation, this court, pursuant to MCR 3.943 Section 8 and MCL 712A.119.1, can at any time amend a disposition. So the scenario that there's a violation of probation hearing and she's not found to have violated, this court still has the right to detain if I find that she's a threat of harm, and the court still has the right to do an amended disposition. Say they never file a violation of probation. They just file a paperwork saying, will you consider an amended disposition, ma'am? Yes, I will, because the court rule and the statute provides that disposition may be amended at any time as the court considers necessary and proper. You're focused on the wrong thing. I get to focus on what's in the best interest of this young lady at whatever hearing is called. If there was never a violation of probation, she still gets an amended disposition because her mom keeps calling the caseworker and saying this ain't working. If there is a violation of probation, but I find her not guilty, she still gets an amended disposition because her mom's calling the caseworker and saying this isn't working. And I was concerned and made a clear record that I was concerned when I gave her the probation try. I don't want to do more harm than good ever by placing a kid on probation who I think can't succeed. And in this case, I placed a kid on probation that I was worried maybe couldn't succeed, but because of the pandemic, I made that decision for her. Mom's numerous phone calls to casework quickly informed the court that she couldn't make it on probation, and that's okay, because we offer incredible services for juveniles in Oakland County. So she was briefly detained, awaiting her amended disposition, and now she's enjoying the incredible services of Oakland County. And here's the good news. She can do it. Look at what she's done in the short time that she's been in programming. She is exactly where she's supposed to be. She can do it. The perfect scenario for this court is when I sign the order sending this young lady home, that I am confident that they're going to succeed and that there isn't going to be an incident within 30 days or 40 days or 7 hours. She goes home and she has had a chance to learn about herself, make some adjustments, and benefit from therapy. Her mom has had a chance to engage in a parent project, parenting classes that will help her. So the two of them come back together, same people, but with those adjustments made that will make it way more likely that they're going to be able to succeed and get out of this pattern of conflict, verbal fight, physical fight, law enforcement involvement, or diversion program, or mental health order, or child protective services involved, or youth assistance involved. Let's get them out of that cycle of domestic violence. Let's get them out of it. She's not having issues with domestic violence anywhere but at home. So let's get them apart for a bit. Same thing as mom thought more than once. Send her to the cousins for a few days. I'm going to go in the car to remove myself from this. There's a reason why mom was making the decision to separate them at times. There's a reason why mom, in her heart of hearts, expressed to people, she needs inpatient, she needs long-term residential. She was right. She's getting it. The worst thing I could do is say, you're doing great, now let's get you home and watch the whole thing blow up. She is exactly where she needs to be. The programming is appropriate. Her educational needs are being met. She's blossoming there. She's open, she's engaged, she's taking care of the dogs. She should be there from the, I'm going to let her succeed. I'm going to let her commit to this from the beginning, work through the middle, and get to the end. And then get back home in an environment where they're both going to be emotionally healthier and calmer. It's the right thing.
Your Honor, I'd like to finish my closing at least.
Go ahead.
At least let me make my record. So
Well,
essentially,
you were asking for Ms. Tarpeda. I mean, you can tell me why you want her to, your co-counsel said you want her home. How is it in her best interest that she goes home?
I don't know how it's not in her best interest. We listened to two people. Mr. Ruitt's not here. I did not hear anything that not the executive order. 4 times the governor said on executive order 29, 62, 119, 146. 4 times the governor instructed the courts. Juvenile detention centers are strongly encouraged to reduce the risk that those at their facilities will be exposed to COVID-19 by implementing as feasible the following measures: eliminating any form of juvenile detention or residential facility placement for juveniles unless a determination is made that a juvenile is a substantial and immediate safety risk to others.
Counsel, how many times does she get to jump her mom before you think that she's a threat of harm to her mom? How many times?
Just like the court.
How many times?
No, Your Honor, that is not the question in front of the.
That's the question that I'm asking you. How many times does she get to jump her mom, bust her lip, bite her, choke her, pull her down on the ground? How many times, pull her hair out, until you think maybe there's a threat here?
The court just made it clear to me just 1 minute ago that the court found that my client didn't do her schoolwork, even though the school had no problem with schoolwork. And if that was a probation violation, maybe I wouldn't be standing here. The probation violation had nothing to do with any sort of violent act. There was no tampering with the GPS tether. There was no.
That's his motion, or your co-joined motion for reconsideration. Do you understand that this court has the sacred obligation and authority to make an amended disposition at any time the court considers necessary and proper?
Absolutely.
I'm asking you, do you understand?
I do. It's
Okay.
3.945A1, and it cites MCL 712A.18, and it says right in there, Judge, I wrote it out, and I'm sure you're looking at it, the court can release my client to her parents so long as my client doesn't present a substantial risk of harm to herself
Yes,
or to
okay.
society. And I
I've heard your
didn't hear
argument.
that testimony.
I've heard your argument. Mr. Prosecutor, do you care to make a recommendation? I kind of got the cart before the horse a little bit in that I think I showed my hand.
No, I understand, Your Honor. My response is, it is the position of my office that we concur in the defense's request for purposes of today's hearing.
Okay, I accept your concurrence, and I have a sacred obligation to do my job, and there is not, this one isn't even close. Not even close. She should continue her TAG program, continue to engage in benefit. She's exactly where she needs to be. This court has the authority to amend a disposition at any time. You can flush the violation of probation out of the process if it makes it easier to understand. The amended disposition that was held on June 4th was the right thing. It's the right thing today. She is a threat of harm under our current circumstances without the mental health treatment she needs and the interventions to get, so she can get a handle on herself. There's not a question in my mind.
Judge, is there any, Ms. Odom Foxworth, would she?
Please stand when you're approaching.
Sure, yeah.
Please stand.
I'm sorry.
Please stand when you're
I
speaking to the
apologize.
judge.
Thank you. Does she want to be heard?
She
Sure.
does, Judge. She
Go ahead.
made a statement.
Yes.
So can I really,
You can do it right there. I can hear you.
I'm gonna stand.
No, you don't have to. Go ahead, because you're reading.
Good morning, Your Honor.
Can I ask you this, honey? When did you write this?
I wrote this yesterday.
Okay, so before everything that happened today, before the counselor said what they said, and the psychologist said what they said, and the lawyers made all their arguments, this is what you were thinking yesterday.
Well, half of it is.
Half of it is.
Yes.
Okay, go ahead.
Good morning, Your Honor. I would like to start off by saying I take full responsibility for any actions I made in the past years, and I know they were wrong. I have grown since 2017, and each year till now, there has been progress. I would also like to note during house arrest, no altercations had happened, and the day I was sent to Children's Village, I had been going to MRT group once a week, family therapy, and individual therapy twice a week, and tutoring once a week as well. I would also like to say, which has started 2 weeks prior to my court date. I would like to note I do well in structured environments overall, whether it's camp or detention centers. I also was doing well with family therapy at home and doing well in MRT group. I don't have any issues with peers or other adults, and I'm getting behind in my actual schooling while here. The schooling here is beneath my level of education. And I know that you may not seem that this is a punishment, but in my heart, I feel the aching and the loss as if it were a punishment. My mom wanted to get me help anywhere else but the judicial system. And I am not doing well emotionally. I also want to say, this last month has been very eye-opening. From sleeping somewhere every night I don't want to be, to 15-minute conversations with my mom on the phone. To be honest, I've learned more about my mother's and our relationship in the last 2 months than I have in my entire life. But I know if I were to go home, I would be able to walk out with a different perspective on life. And I know I would also walk out with a newfound patience. Yes, this all sounds perfect, but I'm fully aware if I were to go home, everything would not automatically just be perfect. And it wouldn't be even if I were to finish the program. But I've learned that life has challenges. And everything happens for a reason. And I believe that this challenge has specifically brought my mother and I finally back together. And this challenge I'm talking about is going through this process. But with each challenge, I learn something and try to analyze why it happened. And each day I try to be a better person than I was the last. And I've been doing that since even before I was in this situation. So in conclusion, I believe placement in my home with the same consistent therapy that I was getting beforehand, and love and support that will always be surrounding me, will be beneficial for myself, my mom, my family, and my community. Thank you.
Thank you. All right, let me tell you something. If I strapped you to a lie detector right now and asked you if everything you just told me from your heart was absolutely true, and you said, yes, it is, you would pass that lie detector test. There's not a question in my mind that you sitting there, a 15-year-old young lady, from your perspective, believes that you've got enough work done in the last 6 weeks in your heart and in your head that you can go home and you're acknowledging it wouldn't be perfect, but that there wouldn't be an assault or that there wouldn't be issues. You get to think that. I have to look at it from a parental perspective, from the perspective of someone who is making some decisions for you in the place of your parent to some extent at the moment. The goal is you and mom safe, healthy, happy in the home. We disagree about what it looks like to get to that goal, you and I. You think you're ready, I think you're not. I think that you're exactly where you're supposed to be, you're blooming there. But there's more work to be done. You have work to be done. It is not done yet. You've set some therapeutic goals. You haven't achieved those goals yet. There's conversations that you need to have with your therapist, and they haven't happened yet. There's more work that needs to be done. When I send you home, when I sign that order, I want to know that I have done everything I've got in my toolbox to give you everything you can have in your toolbox. Ayanna, you've made a point more than once at different hearings that you feel sometimes I'm paraphrasing, you feel like you're working harder than your mom sometimes on this. Let's give your mom an opportunity to do the parent education through Children's Village. Let's give her an opportunity to do that. Let her do her piece of work over here. You do your piece of work. Apart though. It's okay for you guys to be working separately towards a mutual goal so that when you reunite, it is successful. There is not a question in my mind. If I were to grant the request to release you home today, I would be making a mistake and I would be doing you a disservice.
Your Honor, can I
Yes.
just respond? This last couple of months has been very hard for me,
Sure.
not just because I miss my mom,
Sure.
and just because it seems like I'm doing well in this program, that is not what I know. I know I don't need this program. I can get the exact same treatment, if not better, at home, in my home. I got therapy twice a week at home, basically 8 times a month, and I only get it twice.
Did you hear that there's a sign, you know about the sign-up
I know
sheet?
about the sign-up sheet.
Okay,
but
hang on, there's a sign-up sheet, so if your complaint is that I'm not seeing a counselor often enough, if you didn't know before, you know now, if you need to talk to her, there's a sign-up sheet. This is a pattern of behavior. I don't have to speculate. This is history. This is a pattern of behavior. This is your mom, you have an incident. Your mom appropriately, 100% appropriately exercises her good parental judgment. She asks for help. I need help. I get help. Everyone does their job. The caseworkers do their job. The assistant prosecutor does his job. Law enforcement does their job. The therapist, everyone's doing their job. But there comes a moment in time where your mom takes the position, not that I want help, but I don't want that help. I don't want it to look like that. I don't want it to sound like that. I don't want it to come from that source. And you can't control everything when you're trying to get your child's needs met. So I'm basing this decision on what has historically happened. And I want you to finish. The dogs want you to finish.
Your Honor,
Truly. Hang on. You gotta listen, kiddo. You made a commitment to something. You're working with the dogs at the shelter to prepare them for adoption, correct?
yes,
That matters. You made a commitment in therapy. You set goals for yourself. You said, I want to be a thoughtful young person. Here's what's wrong. Here's what I got to do to try and fix it, and I'm going to make a commitment to do that. Give yourself a chance to succeed. Give yourself a chance to follow through and finish something. No question in my mind you miss your mother terribly. Your mother misses you terribly. No question in my mind. The right thing right now is for you guys to be separated until when I put you back together, I know it's not going to end in a physical altercation the minute she says no phone. And you decide, I'm taking the purse, I'm jumping her, I'm stealing the iPad, I'm going in the boys' locker room, I want the social media. You got to work on that stuff. And you haven't even gotten started on that stuff. Until that is, you have work to do, young lady.
I agree. But
And I am with you all the way.
I just want to say, there was no altercation since November. I have been doing well. I can control myself, and I feel like I know that you may believe I cannot, but I know I can. And even when it was November, that altercation, that shouldn't be defining who I can be now.
I couldn't agree with you
And
more.
I know I hadn't had any altercations with my mother, and it just doesn't make any sense because that just proves that I can be respectful, I can be obedient, I can listen to my mom. That doesn't, I feel like that's being totally disregarded, no offense.
I completely agree with you that what happened 2016, 2017, 2018, 2019, and to where we are now, you're absolutely right. Today is our day. It does not define you. You have to do what I have to do. You're going to drown out the noise, you're going to work hard, and you're going to do what's right to get you poised for success. Other people might not think that you can complete this program and benefit and engage long-term. I think you can. So I am respectfully denying the motion for release. I'm respectfully denying for a change in disposition. The disposition order stands, and may I please have a review date for 3 months, please?
Do you want to keep the September 8th date?
No, it should be, I mean, unless it's 3 months, forgive me for not even knowing. July, August, September, is that 3 months?
October.
I don't mind going September 8th, I'd like to know how things are going.
Are we keeping the September?
Why don't we
8th, Your
keep
Honor?
the September 8th? It's in everybody's calendars. Councils, is that date acceptable to you? I believe, correct me if I'm wrong, I think it's September 8th at 1:30.
Correct.
Okay, so we'll just keep that date. It's a little short of the 3-month review, but I know everybody's going to be anxious to know how things are going and how she's doing, and I look forward to that review date.
Are we
Okay?
getting a written order from Your Honor this morning, or?
I will prepare a disposition sheet. It probably won't happen, it's not going to happen immediately.
Okay.
But I'll prepare a disposition sheet that just indicates that an amended disposition was held and that she's continued on the order.
Okay, thank you.
Okay, thank you, folks.
Thank you, Judge.
Court is in recess, all rise.